Thompson, Dorfman, Sweatman is wonderful to sponsor the Mining and Mineral Convention, and I'd like to welcome Allison Fenske and John Stefaniuk, who's going to be talking to us about consultation, Big C and Little C.
Good afternoon, everyone. We're here to talk about consultation with First Nations in the context of primarily the recent Supreme Court of Canada decisions in the Chilcotin case out of British Columbia, and also the Keewatin or Grassy Narrows case out of Ontario. And to start things off, I'm here with my associate Allison Fenske. My name is John Stefaniuk. We both practice in the Winnipeg law firm of Thompson, Dorfman, Sweatman. And I do mostly natural resources and environmental work, and Allison does natural resources and Aboriginal law work. And I'm going to let Allison start us off.
Okay, and so just to start things off, I wanted to make sure that we set the stage for what we're talking about in terms of the legal duties around consultation. That word can mean a lot to different people, and as it's something that we have been talking about from a legal perspective for at least 10 years, I wanted to go through it just quickly and remind everyone that it's the Crown and not private parties that ultimately owe Aboriginal people a duty to consult and accommodate, and that comes out of a trilogy of Supreme Court decisions in 2004, the Haida Nation, Taku River, and Mikisew decisions. The trigger for that duty is that when the Crown has actual or constructive knowledge of a right and is contemplating action that could adversely affect that right. And in the contemplation of action, we're talking about, for example, permits around explorations and access. Those are all things that could trigger that duty to consult. And in Manitoba, it's particularly important to think of this in the context of the treaties and the numbered treaties that were signed throughout our territory. We're currently in Treaty 1 territory here in Winnipeg, but ultimately the Crown's deemed to have knowledge of these treaties, and so there's no need to prove knowledge when it comes to treaty rights as long as there's a potential adverse impact within a treaty group's traditional territory. So then, with respect to consultation, in setting the duty, it exists on a bit of a paradigm, and there's a requirement that you examine the strength of the Aboriginal right that's being asserted against the severity of the potential impact. And so because of that, the duty and how Crown parties affect the duty can range from notice to a disclosure of information, to listening to certain responses on one lower end of the scale, to having an Aboriginal group be able to make submissions in front of, for example, a Clean Environment Commission or other regulatory bodies, be formally part of the decision-making process, be given written reasons from the government in terms of their permitting decisions. And there's ultimately no duty amongst the Crown and Aboriginal groups to reach an agreement, and there's also no veto power at this point recognized in Canadian law, although some groups will assert that there are veto powers in place, so that you need to be aware of that. Both parties ultimately have to approach this in good faith. And this is all something that we're discussing because it ultimately has an impact on the strength and success of industry projects, right? And I also wanted to, in this moment, just refer generally to a recent decision out of Saskatchewan, the Buffalo River Dene decision, where it was determined that a right to explore, so there was a permit granted for an exploration rights, but it was determined that because there were no actual access rights attached to that permit around exploration, and that the access rights had its own separate permitting process, that the mere permit around exploration didn't actually trigger a duty to consult because it was found by the courts that it didn't have a potential at that stage to impact the Aboriginal rights in play. So it's not a given that there will necessarily be a duty to consult in every case. And so with that, we'll turn to, I'll give the mic back to I'll turn to the Chilcotin decision and the Grassy Narrows. I'll talk about Chilcotin for a few moments, and John will take over with respect to Keewatin and Grassy Narrows. So with the Chilcotin, we're talking about a semi-nomadic group out of BC, and they had claimed title over certain tracts of land in the west central interior of the province. And for the first time in June of 2014, this year, the Supreme Court made a declaration recognizing Aboriginal title over a large tract of the land that had been claimed. And so, with respect to Aboriginal title, once the title has been established, and in this case it has been for the Chilcotin, development of Aboriginal title lands by the Crown or third-party developers can only proceed with the consent of that First Nation who has title to the land, or with the Crown demonstrating that it has discharged its duty to consult and to accommodate and can justify any infringements of those rights and of that title under the Sparrow framework. And so that's the Supreme Court's framework for how you would infringe on Aboriginal rights, which, given time constraints, we don't have time to get into today. And so the reason why we're talking about the Chilcotin decision and recognition of Aboriginal title in BC, first of all, we should acknowledge that on the face of it, it's going to have limited legal implications in Manitoba because of the treaties and because the numbered treaties are seen to be an extinguishment of Aboriginal title across Manitoba. However, it's very important to note that it is a significant decision in favor of First Nations, and it will likely have the effect of affecting the positioning of other First Nations and Aboriginal groups. I can tell you from experience with some of our clients who are generally on the industry side of things that we are seeing an increased reference to Aboriginal title even here in Manitoba, even with the surrender clauses in the numbered treaties, and that's notwithstanding the existence of the treaties. And it's also important to recognize that there's a variety of understandings of what the treaties actually say and promise. And so oftentimes we're relying legally on the written text, which is the English version of the treaties, and the language of surrendering and ceding and extinguishing title all comes in the English written text. The First Nation groups may have a different viewpoint, and we've seen that come up time and time again, about whether or not those treaties really do surrender land, or whether, in keeping with the oral history and traditions of the group, they're more of a relationship building and sharing agreement and don't necessarily cede that land. If it's found that there is no surrender aspects of the numbered treaties, then you would have an issue of unextinguished title here in Manitoba. And so really it's important to recognize that the Chilcotin decision can sometimes be a lightning rod for a renewed call for justice and reconciliation, and a renewed focus on Aboriginal and treaty rights, and in this case on Aboriginal title. And ultimately those are decisions and issues best dealt with on a nation-to-nation basis or a government-to-government basis, but it's important for industry to be aware and also to potentially be proactive in the ways that you can be when you're dealing with certain projects.
So the Grassy Narrows or Keewatin decision comes out of Ontario and dealt with largely constitutional issues. The First Nation challenged the ability of the Ontario government to issue permits for forestry licenses in this case, without having to go back to the Government of Canada, because at the time the treaties in Keewatin, you have to go back to the old history and geography of Canada at that time, and at that time most of Northwest Ontario, most of Manitoba, part of the Northwest Territories, was all considered to be the Keewatin district, all under federal jurisdiction. In fact, in Manitoba didn't get jurisdiction over natural resources, and Manitoba, Saskatchewan, Alberta for that matter, didn't get jurisdiction over their natural resources until the constitutional amendments in 1930. So the Grassy Narrows First Nation said, we don't recognize this license because Canada wasn't involved in approving it. Our treaty is with Canada, therefore there's another step that's involved. The Supreme Court decision is significant for a number of reasons. Number one, it said that no, there's only one crown, and the crown includes the provincial crown, and with all the history and the fact that part of the Keewatin district became part of the province of Ontario, and Ontario had jurisdiction over those natural resources, that meant that Ontario had the duty and the obligation to do the consultation, and there was no need to get the federal government involved in an area that fell within provincial jurisdiction. It also determined that provincial laws apply to First Nations, and that the other interesting aspect is that the First Nation, the treaty was recognized by the Supreme Court without any real discussion. One of the first things that the court says in the decision is that the land was ceded by Treaty Number 3, and that formed the basis of the rest of the discussion. So Ontario was recognized as having the right under the treaty to take up land within the province that was used for the First Nations residual hunting and fishing rights within that within their traditional areas. But it also emphasized that the right to take up land in a way that might interfere with First Nations rights and Aboriginal rights is subject to that duty of consultation and accommodation where necessary, as Allison referred to, and that there are limits to it. You can't ignore the constitutional rights of the First Nation by taking up so much of the rights that it has the effect of effectively extinguishing or ignoring the residual rights to hunting and fishing. So that's the context, and for resource developers and for government, I like to distinguish the two types of consultation as I see it. I call it big C consultation and little c consultation. The little c consultation is the kind of consultation that you will do if you're a developer, if you're a concerned person that's going to do any kind of project. If I'm going to get a permit to put a front porch on my house that my neighbors might not like, I'm going to go and talk to my neighbors. I'm going to go talk to the people who are potentially affected and find out what their concerns are and try and address those concerns as part of my approval processes before I enter into any kind of approval or permitting process, so that when it comes time to speaking with the government agency, I can tell them that we've done our best to address these concerns, and here's what we've done, and here's the consultation we've had, and whether it's going to be, we're going to be providing employment, we're going to be providing facilities, we're going to be doing these sorts of things on a voluntary basis with the First Nation or the affected group, whoever it may be, that we've done that, we've put that in place. I call that the little c consultation. The big C consultation is the constitutional duty of consultation to satisfy the obligations of the Crown to consult and to accommodate. Some jurisdictions will delegate some of these responsibilities to developers. Manitoba at this point really doesn't do much of that delegation. But that big C consultation, the constitutional duty to consult, and where there are significant impacts to accommodate these rights, treaty rights, is something that falls squarely on the Crown. And in most cases, that means the provincial government. Now, in the big picture, this is not something that industry can resolve. In my view, this is something that is, as Allison alluded to, a government-to-government issue. What industry is looking for is relative certainty as to knowing what it is what the rules of the game are, timeliness, that things happen in a reasonably timely way, and predictability. And predictability in the terms of, we know what the process is that we're going to have to go through, and if you have two projects in the same circumstances, then you should be able to predict that they'll both achieve similar results, or that the processes and the end results will be the same, and the requirements will be the same. The only way in my submission to achieve that on any sort of global basis, and to set the stage for both industry, well, three parties, industry, the governments, and the First Nations governments and peoples, to maximize the potential benefit from development, is for government to take the lead with input from industry, but for government to take the lead and with First Nations to resolve some of these outstanding issues, and to put in place a framework as between government to government, that parties know what the rules are, whether that means royalty sharing, whether that means tax sharing, whatever it is, so that the uncertainties surrounding the landscape are removed, and that industry has some clearer expectations as to what it is that it faces when making application for a project-related approval.
And so with that, as John mentioned, there hasn't been a lot of delegation in a Manitoba context, but that is something that regularly happens in other jurisdictions. And so industry proponents really need to be prepared to have the government delegate certain procedural aspects of the Crown's duty to consult onto the proponent. And in a lot of ways, when you think about that in practical effects, it makes sense. Who has the information about the project description, what the proponent wants to do, where they think there might be some room for accommodations and mitigation to, the potential changes, what the primary concerns of the proponent are. Do you want government relaying that information to the First Nation in terms of their consultations, or do you want to have some control over that message and some responsibility in communicating effectively what the needs of your project are? And so it makes sense for the government to delegate some of those procedural aspects, but even if the government is not going to formally ask that proponent X talk to First Nation about their project description, it makes sense for the proponent to be engaged and to be proactive in that way. Open up those lines of communication, because your little C consultations, you're talking and you're making sure that you have good relationships with your neighbors, is ultimately going to assist in having the Crown discharge their duty. And as we said, it's ultimately the proponent and the Aboriginal group that bear the brunt of any failures of the government when it comes to their duties to consult and accommodate. And so you want to be proactive in making sure that that doesn't happen, and to equip the government with the tools that it needs in order to appropriately discharge that duty. And so with that, you want to have a particular engagement strategy. And it's going to look a little bit differently depending on the size of the project, right? Obviously, you're not going to be talking necessarily about the kind of revenue sharing or impact benefit agreements when we're, those often go alongside larger projects, and they're just not necessarily always appropriate or reasonable when it comes to smaller projects, smaller producers. But there are a lot of things that you can still do, recognizing what the project is actually meaning. And so in doing that, it's really important just to open up those lines of communication, have an actual strategy that you're going to implement, and make sure that you're documenting it. And so that might mean having a communications log, making sure that you're summarizing all of the activities that you do in order to engage with neighboring First Nations and the outcomes of those discussions. On this date, the First Nation alerted us to this issue that they're seeing coming down the pipeline with, for example, in Corey's presentation, the migratory patterns of the caribou herds. We got notice of that, and what we did was move some of the major sites around the mining and exploration in order to accommodate that, right? Those are all really important examples of how you can best see out that kind of engagement strategy. And I should note that I have a template that we use often in our office around communication logs and charting interests and concerns that I'm more than happy to share with anyone if you just shoot John or I an email. And so with that, I'll let missed my last page. John's talked a little bit already about, again, taking that proactive approach and considering working to shift the focus back onto the government, right? The solutions for the larger constitutional issues lie in a government-to-government framework, but that doesn't mean that that industry can't be proactive in making sure that its voice is heard. And one of the ways that you can do that is through some of your provincial or local organizing groups. The Manitoba mining industry, for example, has been a huge proponent of having discussions and memorandum of agreement in place and engagement strategies in place. So they're a good resource for proponents, and it's important because everyone's sort of off concentrating on their own specific projects, that you want to have a united voice in making sure that government is listening to not only industry concerns but First Nations concerns, and that everyone's represented in that conversation. And so that can all work towards creating those sort of certain the necessity for certainty, right, for equitable and beneficial environments for both Aboriginal and non-Aboriginal resource users, right? And ultimately, what John and I would like to leave you with is this idea that strong relationships lead to strong projects, right? And so to be proactive and engaged at every level that you can be in creating those strong relationships, because it will ultimately impact the success of your project overall.
And we've gone way over time, so I leave it to the discretion of our host as to whether we can answer any questions.
Are there questions? If not, I'm going to thank you very much, and maybe ask that, because we're in break now, ask that, you come back. Yes, thank you, yeah. So they'll be available to take questions after the break, and we'll try and squeeze in some time. Thanks.